Next argument will be Hegadorn versus Department of Human Services Director.
May it please the court, my name is Jim Stewart, or James Stewart. I'm the attorney for the three appellants in this case, who are the plaintiffs below. And I wish to reserve 3 minutes of my time for rebuttal, and it should be noted on the record, I'm sharing some of the time with one of the amicus brief attorneys, Ronald Lensman.
Okay, please pay attention to your time so you don't intrude on your colleagues' time, if you would. But
correct.
We will preserve the time that you've asked to be preserved.
Thank you. These cases, as you know, are involving Medicaid applications by an institutional spouse who was married at the time of application, and the division of resources or assets and resources between the institutionalized spouse and the community spouse. The starting point, the correct starting point for the analysis, though, in determining whether or not the department has ruled correctly, is to work through the definition of what is a resource. A resource is defined in the statute. It does not mean just anything. There is a particular meaning that is attributed to that under the federal rules. And the best statement of that is found in the Code of Federal Regulations at 416, and that's cited in the briefs. And basically it says that the resources are cash or other liquid assets or any real or personal property that the person owns, the individual or spouse owns, and could convert the cash to be used for his or her support and maintenance. And then goes on to state if the property right cannot be liquidated, the property will not be considered a resource of the individual or spouse. And that is the starting point that has to be used here, because in order to calculate what is a quote countable resource, you have to start with that rule and then go from there. The other important thing is that it is the date of the application that determines what assets are to be counted by the department. They must look to that date as controlling what they are to rule upon. And even if the application is actually decided upon and processed 2 months later, 3 months later, in the case of Mr. Ford or Mrs. Ford, some 8 months later, 7 to 8 months later, it's still the original date of application that applies in that context. The other thing to note is that income is not a resource, and that's excluded in the statute as well. An item of income is not a resource to the Medicaid applicant if that income is to the community spouse. And that's true throughout the process. And that brings us then to the trusts that are involved here, because as has been stated in the briefs, the particular trusts here are what are referred to generally as sole benefit trusts. And there are several different types, but because a Medicaid applicant can create a sole benefit trust for a disabled child, a disabled, another person who's under age 65, and so on. There's other types of beneficiaries that can be used, and one of those, though, is the spouse. So that was done in all three cases here. The trust was created, actually, in some cases it may have been actually by the spouse who created it, but there were because of the wording of the statute, assets were transferred, that some of which may have belonged to the institutionalized spouse, some of which may have belonged to the community spouse. So those were transferred to those particular trusts. And under the federal scheme in 1396P, which is what the Court of Appeals decided was controlling, is that, well, if the institutionalized spouse or the community spouse puts assets into the trust, then it's going to be treated as though, or could be treated as though, the institutionalized spouse created the trust. But that doesn't end the analysis. That's not where we're going with what is a accountable resource and what is not a accountable resource. That just gets us to the point of, well, who created the trust? And the Court of Appeals stopped there and said, well, since they both can be considered to have created the trust, then it's all accountable. And that is not the rule. That's when we get into the 1396 D3 provisions that spell out how this is done. And the wording that's used in this statute is referring to the term individual. And that's used throughout the Medicaid statute, the 1396 provisions and some of the other Social Security-related statutes, as meaning the person who applied for benefits. That's the person who is being referred to. And if they want to talk about the spouse of the applicant, in this case, institutionalized spouse, they refer to that person as the spouse of the individual or the individual spouse. And that's done throughout. In fact, all you have to do is look at 1396P 1, 2, and 3, 1396PD 1, 2, and 3, and you can see right in there that when it's talking about the spouse, it says spouse. When it's talking about just the individual, who is the Medicaid applicant, it just uses that term. And that is the term that's used in the B1 section. It only talks about the individual. If there is a circumstance under which the trust can make payments to the individual, the Medicaid applicant, then it would be countable. But that's the change from the usual accountability rules that applies in the special circumstance that's outlined in this statute. That does not apply to the sole benefit trust because the Medicaid applicant individual was not the person who was the beneficiary. The trust did not permit any distributions to the Medicaid applicant.
Isn't that not true in one case, Counsel? In the Hegadorn case, isn't it the case that the wife Medicaid recipient is the beneficiary if the community spouse dies first under the testamentary instruments?
Possibly under the testamentary instruments, but the nature of the sole benefit trust is that it's supposed to be paying while the beneficiary spouse is alive to that person and only that person. That's the nature of a sole benefit trust.
I understand that, but the statute says if there are circumstances under which the trust can benefit, and isn't that a circumstance under which the trust would benefit?
No, that is not, because that does not apply while the spouse is living, and so there is no circumstance.
The statute doesn't say if there are circumstances while the spouse is living under which it just says if there are circumstances under which it benefits the institutionalized spouse. In that one case, I agree. The other two, the testamentary instruments do not leave it to the institutionalized spouse, but under the one, I'm wondering why that's not a circumstance.
Because that does not apply while the spouse is living.
But
there is no while the spouse is living. That
limitation isn't in the statute. You want me to read that limitation in the statute?
I think you have to, because while under the sole benefit trust rules, in order to qualify, the only beneficiary who can receive payments during that person's lifetime is the designated beneficiary, and in this case, the spouse of the applicant. That's the only person who can receive them, and the department in all three cases determined that that rule was satisfied, the sole benefit trust rules were satisfied, and so that person was the only person who could receive benefits while they were living. Now, if the person dies, then that would potentially change it, but I don't recall right now what the structure was, because there are some trusts that, like
It's at page
testamentary.
204 of your appendix. It says that it reverts to the wife in that one case. So it's in the documents you gave us.
I'd have to look at it again. I don't recall that specific. I know that in some cases what the document will provide is that if the spouse beneficiary, the husband in these cases, dies, then the assets can be distributed to a trust under the will of the deceased spouse for the benefit of the institutionalized spouse, and that is an exception. That's a separate exception where that trust is not countable.
Mr. Landsman, you've used up your reserve time, and you're beginning to use up Mr. Landsman's time.
Okay, then I will leave it there for now, and thank you for your attention.
Thank you, Counsel.
May it please the Court, my name is Ron Landsman. I represent the Friend of the Court, the National Academy of Elder Law Attorneys. So the issue before the Court is how to treat a trust for the benefit of a spouse under a federal statute that very clearly focuses on trust for the benefit of a Medicaid applicant, and then has provisions to say what to do when the Medicaid applicant can get no benefits under the trust. The statute says treat that situation as a transfer, and that takes you to the transfer rules, which then tells you what to do if a transfer is made to someone for the benefit of the spouse. These provisions are, I say, nested in a pretty complicated set of statutes. But a common feature, although there is to provide protections for spouses and disabled children and some others that avoid the standard resource limitations that we're all familiar with. The statute, the 1396 PD, was a statute enacted in 93, and I think it's a brilliant statute because it solves the problem about people using trusts for Medicaid planning. And if you drafted it the right way, you could get the best of both worlds. And what Congress said is, no, we're going to change the system. If you set up a trust for yourself, the Medicaid applicant, then the money is either available to you, forced available, or you've transferred it. And there's no in between. It's really quite a brilliant statute. And then there are sets of exceptions on each side. If it's for your benefit, you get exceptions under D4, where you have payback. If it's for someone else, spouse, disabled child, someone else under 65 who's disabled, it then goes under a sole benefit rule, which once again is designed to protect that person, but also to protect the Medicaid program. And that's what happens here. So let me be clear, the fight with the state is over whether you should read these trusts as for the benefit of the spouse as well as for the benefit of the Medicaid applicant. Plainly, Congress said otherwise. They refer to the statute with the 1396 PD refers to the spouse a couple times. It refers to the spouse when it's setting up the trust or funding the trust. It refers to the applicant, referring to the Medicaid applicant, 21 times, and in not one of those times does it refer to the spouse of the applicant.
Counsel, can I ask you?
Please.
Why would, if I'm going to go practice elder law when I leave the court, why would I ever recommend a client use the annuity provisions that would require that the Medicaid be paid back if the community spouse predeceases the institutionalized spouse over this trust provision? Why wouldn't I steer all of my clients to this trust provision?
That's easy, Your Honor. If you use a trust, you've given up control. You've given the money to a trustee who can use the money only for you and not for any other purpose, and has to use it for you during your lifetime. You've really made, I mean, your question is exactly on point. It's a complicated system, and Congress has approved and set up a number of ways to mitigate the harshness of what began as a poverty program and is not any longer. So there's the spousal resource allowance. There are, you can use annuities, you can use promissory notes, or you can use the trust. If you use the trust, you've done two things. You've tied the money up so that you can't be used for anyone. You've given up control. You've tied the money up so it can't be used for anyone else in the world, and it has to be used during your lifetime. That's the point of sole benefit. That means and you've made the choice. I'm going to get Medicaid for my spouse, but I will not get Medicaid until all of that money that was protected for me has been spent on my assisted living, on my nursing home care, on whatever else I need. So that's exactly a choice.
That's helpful. I tried to figure out. I looked at like elder law sites in other states. I can't find it. Is Michigan just ahead of the curve? Or is our elder law bar just smarter and better than the elder law bar?
I won't concede that, Your Honor.
No, it's okay if we are. I want to know. But I'm curious. Why hasn't this? Why don't we see this in other states?
Because in Maryland, for example, we're allowed to put money into a trust, we can fund a trust for the disabled spouse at home over age 65 by putting money into a pool trust. Many states don't allow that because of there's a fight over what that means. In other states, people can use annuities more. I don't know the limitations in Maryland, but you can use annuities.
But if you use the annuity, and the community spouse predeceases the institutionalized spouse, the annuity then has to repay the Medicaid payment.
No, I understand that, Your Honor, but clients, choose to take that risk. I mean, the goal. My client spouse says, "I need money to live on, and if I could turn it into income for you," says, "Okay." She's not concerned about providing for her kids when people make that choice, and it works.
But it's just so is it that clients in Michigan just think differently about these? I just don't understand why. This has been the rules. This isn't a new rule. Why are there no cases around the country?
A number of states, other states, for example, follow what's called the assignment rule. New York, Connecticut, and New Jersey, and D.C., where if the spouse says, "I'd rather not use my money, but if you want to sue me for support, I'll pay support, but I can get to keep my resources." And so in some jurisdictions, that's an attractive alternative to tying the money up in a trust. The answer is, and there's actually a recent case from your Court of Appeals that you can court support orders. So a number of jurisdictions, we tend not to use them in Maryland very much, but a number of courts are quite liberal in using spousal transfer, resource transfer orders. If a court authorizes the transfer to the community spouse, the amount that's transferred, if it's higher than the normal resource allowance, becomes the new resource allowance for the community spouse. So therefore, you're right.
So other states just have different rules in how
That's right. And
gotcha.
some are popular in the West. I mean,
Gotcha.
And some are popular. It varies from county to county as well, Your Honor. But that's part of both the complexity of the way Medicaid works and what Congress has put in place and how people, we work with our clients to figure out all the choices. So there's maybe, I just want to stick with the technical issue for a minute, because the way the statute is written, it says whichever spouse puts money into a trust, if it's for the benefit of the applicant, it comes under these rules that say it's available. Think of it like a funnel. Whichever spouse puts money in, if it's going to the applicant, it's available. The state wants to turn the funnel upside down and say, well, if the applicant puts money into the trust, whichever one it goes to, it's available. But that's not the way the statute is written. The statute is written very clearly and very carefully to limit its aggressive application, forced availability, only to trusts for the benefit and payable to the Medicaid applicant, not the spouse. Once you recognize, and the state's case depends upon forced availability. That is to say, if there are any circumstances, then it's considered available to the community, to the nursing home spouse. Once you're outside of that rule, how does the statute treat it? It treats it as a transfer. And that takes you over to the transfer rules. And the transfer rules have a number of exceptions. Transfers to anyone under age 65, transfers to a disabled child of any age. Sole benefit of someone under 65 who's disabled, sole benefit of a disabled child, or the sole benefit of your spouse. And so for the people who want to make that choice, the money can be put there. At that point, from the spouse's point of view, the community spouse's point of view, it's a third-party trust, and those trusts are somewhat more friendlier in this context and result in the assets not being available. The department says that this gets around the spousal rules, and it's true. It mitigates the effects of the spousal rules just the way annuities do, just the way promissory notes do, just the way other types of transfers do. The federal agency that regulates this system recognizes that. The Center for Medicaid Services, the Medicare and Medicaid Services, in their what we call Transmittal 64, the state Medicaid manual provision, says if you use a trust that meets all the requirements of sole benefit, it can affect eligibility. And all the state's arguments are in the face of that absolute acknowledgement by the federal agency that that was Congress's purpose, and that's one result. I think I've used up my time, Your Honor.
Are there any further questions?
I'd be happy to answer any questions.
Thank you, Counselor.
Thank you.
May it please the Court, Chief Justice Markman, esteemed justices, my name is Geraldine Brown. I'm an Assistant Attorney General, and I represent the Department of Health and Human Services in this matter. This case goes to the very heart of what Medicaid is and what it is not. It goes to the heart of who benefits from Medicaid and who cannot. Medicaid is intended for the needy, who otherwise could not provide medical services for themselves. And Medicaid is a limited pool that must be husbanded to provide care to those who really need it. It is not a subsidy, it is medical care. And because it is for the needy, it is means tested. No one disputes that the three couples here all had too many assets to qualify for Medicaid, and that's even after they would receive all the benefits of the additional assets and additional income that the Medicaid Catastrophic Care Act allows them. And no one disputes that they put their excess assets into a trust in order to evade the Medicaid limits. And no one disputes that the assets of both spouses, regardless of how they're held, are counted for the eligibility of the institutionalized or nursing home spouse. Appellants are arguing that millionaires or anyone with excess assets, and that's regardless of any amount, can qualify for Medicaid long-term care and put the burden on the taxpayers to pay for their nursing home care just by putting the assets into a trust. And that is not what Congress intended. It is not what the law says. If Congress wants to provide nursing home care to everyone, it will do so, and it will also provide the funding, which it has not done. I would waive the rest of my free fire if you have questions.
That sounded like a great speech to be given from the floor of Congress.
Oh.
What you just said. Let me just ask you, 42 U.S.C. 1382 relating to Social Security benefits has a similar any circumstance rule, almost identical to 42 U.S.C. 1396 PB, etc., except that it specifically provides that any portion of the corpus from which payment to or for the benefit of the individual or the individual spouse is countable. Yet Congress didn't include it in the provision we're looking at today. How are we supposed to take that?
We believe that both sections are applicable and that they come to the same result. If you look at 1396,
So in the Social Security Act, it really wasn't necessary for Congress to say that?
to use the spouse,
Individual or of the individual spouse is countable.
that's correct. It's not necessary. In reading the law,
It's
in
just
reading
extra language that they didn't need to use.
No, it's the way that the Social Security, the SSI standards are generally written. They always mention the spouse. But you do come to the same result if you logically follow through the statute. And Hegadorn, on page 569, did exactly that. They said that it is clear from the statute that assets means all assets of either spouse. That is the institutionalized spouse and the community spouse. So if the trust pays to the community spouse, her assets are for eligibility deemed to the institutionalized spouse.
All right, I want to stick to the language of the statute. 42 U.S.C. 1396 PB1 directs the reader to section D3, where it says the individual referred to in D3. Doesn't that logically refer to the same individual referred to in D1? And in that case, which is the applicant?
The section D1 does not exclude, excuse me. I want to look at the exact P. And
42 U.S.C. 1396 PD1 states that, quote, for purposes of determining the individual's eligibility, the rules of 42 U.S.C. 1396 PD3 apply to the, quote, a trust established by such individual.
it does not say that it won't apply to any other trust for anyone else whose assets must be counted. That is referring to people who have special needs trusts. Congress went to very explicit detail to say that if you have a special needs trust, if you are an individual, you have put your own assets into a special needs trust, and you qualify, and qualifying requires that you be under the age of 65 and that you be disabled under 1382C and a number of other provisions, then you can keep those assets. Those assets will not be counted against you for eligibility. But for everybody else, Congress essentially made two kinds of trusts. There's special needs trusts where if you qualify, your assets don't count against you. They will count as income as you take them out. But you can have Medicaid, and this special needs trust is intended so that you can have those special things, a van, a special wheelchair, all of those sort of things. You get down to Section 2, and that's what explains for everyone whose assets must be counted for eligibility. And we know that for a Medicaid eligibility for long-term care for medically needy couples like the Hegadorns, Lawlers, and Fords, the assets of both spouses must be counted. And there is no reason...
Can I ask you, how do you reconcile that? I guess I'm following up on Justice Zara's question, but how do you reconcile that with the fact that the immediately previous provision, 1396 PD2, refers to the individual and the individual spouse? Doesn't that further suggest that the individual in the provision Justice Zara is asking about is in fact the person applying for benefits and not also that person's spouse?
Which section are you looking at now?
1396 PD2A.
D2A, yes. All right, I've got to get back to my trusts. Yes, what it's saying there is, we know that you have established trust. Any individual any individual on this planet has established a trust if either the individual's assets are in the trust or the individual's spouse's assets are in that trust.
But the point is it knows how to differentiate between those two categories there, but it didn't do that in the provision that Justice Zara just inquired about.
Refers to 3. Section 1 which refers
Section 1. Section 1 is intended to carve out the exemption for paragraph 4, which is the special needs trusts. And in fact, when it tells us about the trusts, and this is a section that the Hegadorn court cited, 42 U.S.C. 1396 PD in their trust section at 2C says that this section applies, and that is the section that tells us what's countable in a trust, applies without regard to, and it says any restrictions on when or whether distributions can be made, and any restrictions on the use of the distributions. So the fact that they just go to the community spouse isn't significant. We know from 42 U.S.C. 1396 A 17, section 17D, that the assets of the spouse are always deemed to be available to the institutionalized spouse.
You know, it's not only this internal inconsistency that concerns me a bit, but I think you cite elsewhere in your brief the supplemental security income statute, and that fairly routinely refers to the individual in the context of the any circumstance test, whereas, I'm sorry, that refers to the individual and the individual spouse, whereas
yes.
This statute refers just to the individual. I understand that they're separate statutes, but it seems to me it's a relevant thing to compare those statutes,
Yes.
just as it is to compare the internal provisions of the Medicaid statute.
They have limited the term individual to mean applicant. There's nothing in the statute that actually implies that. An individual, when they're talking of this is the general rule for trusts. And how do you know how to deal with assets in a trust for anyone whose assets must be counted? Any individual. And this is the way any individual's assets will be evaluated. They would like you to believe that even though Congress says over and over again that the assets of both the institutionalized and the community spouse's assets are combined and deemed available to each other, that there would be no way to evaluate what they put into a trust. No state permits this.
Counsel, I just have a very basic question. And the thing I'm just trying to understand is if I create an irrevocable trust, the spouse doesn't really have access. It's not liquid. I can't control it. It's irrevocable. And I guess the question is that if you create an irrevocable trust, who really has control of the money from that point?
Well, they made these sole benefit of trusts, which only exclude them from getting a divestment penalty. But they made them so that it must be spent during their lifetime. But most of them, that money is immediately available the day after the eligibility determination. They've limited to after the eligibility determination because they wanted that date to say, oh, it wasn't available to anyone before that date, so you can't count it. But the D2C is pretty clear that it applies without those restrictions. That time element doesn't matter. So, yes, for the most part, those assets were immediate. She could take them in, he, in this case, they were all husbands, they could have taken those assets the next day and had them all in cash, put them in an investment account. So no, there was no limitation there. They could have set them up if they had wanted them to be limited, but they didn't. They just had to be, it just said they had to be paid to them within their lifetime. Yes, they could have gotten it tomorrow.
There was no limitations. There was no, even though it's an irrevocable trust, the money was accessible, available, and open to them at that point?
They put in, the money was, of course, completely available to them till they established the trust.
Right.
They deliberately chose to do it. They put it in, and the provisions in one of them said the first distribution cannot be made until after the eligibility determination. Another one said that it couldn't, the first distribution, which could be everything in these cases, first distribution took place May 15th. And the third one, the Hegadorn case, never had any limitation whatsoever. They could have taken that money at any time. It was always available to them.
Are there any further questions? Well, thank you, Counsel.
Thank you very much.
Does anyone have any questions for the appellants?
I actually do. I'd like to hear your response to Sister Counsel's comment. Is the money, in fact, available at any time without reservation?
This is Mr. Stewart responding.
Yeah, this is, no, it is not, because the trustee is the one that has to make the distribution. And as was indicated in the brief, and maybe I didn't mention this in the oral part of this yet, distributions from this type of trust, a irrevocable trust, to the beneficiary, in this case the spouse of the applicant, under the Medicaid rationale, the Medicaid statutory structure, that distribution is income. That is counted as income under the Medicaid system, and the Medicaid system states specifically that no income of the spouse of the applicant is counted as available to the applicant, very specifically.
Right, but I just want to understand the simplistic fact. If an irrevocable trust is created, can you go in and take that money? That's what I want to understand.
Can the trustee give, as soon as the eligibility determination is made, can the trustee then distribute all the money back to the community spouse?
That would depend on the terms of the trust. That might be applicable in some trusts. That's possible.
Is it applicable in any of the ones in this case?
It says, I think that all of them actually say that the distributions have been made to the spouse of the applicant on an actuarially sound basis during the lifetime of the person. That does not prohibit, though, I will acknowledge, it does not prohibit making a larger distribution to the spouse beneficiary. So it is possible, once again, depending on the wording of the trust, to make a larger distribution after the particular time has gone by. But if that's done, that is income to that person. It's after the application has been processed, presumably, and at that point, then it's not countable as the applicant's income or asset because it's income to the spouse. This is just like the annuity situation. This was discussed in the Hughes versus McCarthy case that's cited in our brief. And I also want to mention that the Hughes versus McCarthy case also addressed your question regarding the contingent beneficiary and analyzed that and said that it would not adopt that rationale that if the current beneficiary dies, then therefore it's countable to whoever gets it next. And it cited the Center for Medicare and Medicaid Advocacy and their Center for Medicare and Medicaid Services and its analysis. And in fact, that department actually filed an amicus brief in that case that addressed that. So the any time in the future thing doesn't apply to contingent beneficiaries that might take if the current beneficiary dies. That's not normally within the control of anybody.
So if we go back to a larger distribution being coming from the trust to the community spouse, that could then impact the Medicaid eligibility of the institutionalized spouse?
No, It does not, because after the person is in the institution, then, in fact, before and after, no income coming to the spouse of the institutionalized spouse is countable to the institutionalized spouse.
Why wouldn't everybody do this then? I still don't understand
Well,
why everyone, we should all do this.
As Attorney Landsman was saying, there's pros and cons to all of these different options. You know, annuities are one. There's a few others that are permitted under the statute very specifically. And so there's pros and cons to all of them.
What's the risk? What would the risk be?
What are the cons?
Yeah,
It
what's the
seems like a
risk?
lot of pros to this one. Let's see.
So if I'm in this situation, what would the risks be for doing this?
Oh, well, one risk is that, as Attorney Landsman said, that you're losing control of the assets and relying on the trustee to follow what they're supposed to do, and sometimes that doesn't always happen. And the only contract you have is the trust. So you may be left with having to enforce whatever the trust says to make sure your rights are protected. So there is risk there. But the other thing that's really important here, there's the claim, well, millionaires would do this. Well, millionaires don't do this. Millionaires aren't going to put themselves in a nursing home when they don't need to, if they can afford to pay otherwise. That isn't what's done. Could it be conceptually done? Well, maybe, but why do that? People want to make sure their care is provided for. The Medicaid system is not a perfect system. That's not the best way to get care. If you have the money to pay for it, otherwise, that's what most people will do. They don't want to rely on the Medicaid system. What happens here in the middle class, lower and middle class, is they don't have the funds. They don't have any choice. They have to do something to avoid the spouse losing everything. And in the examples, the Lawler case is particularly graphic. They only had like $40,000 to $50,000 altogether, total, between the trust and what wasn't in the trust. We're not talking about rich people. In the Hegadorn and Ford had a little bit more, 400,000 or so. This is what the spouse has to live on the rest of their life.
Okay, your time is up, counsel, unless there's anything further.
Nothing further. Thank you.
Thank you all. Case will be submitted.